project or continue on with it. I'm not really sure that we're going to make our deadlines or our perceived deadlines on these broadband projects, but it'll be interesting to see how it works out. I know in my area in far northern Coos County, it's an enormous problem if the kids need to do the remote learning. The satellite dishes just don't work up there as well as they should. And we really do need these programs to continue. That's really all I have to say. I just wanted to put in our 2 cents worth in the North Country to let you know that we're very actively interested in any legislation that will help us. Thank you very much.
Thank you, Representative. Any questions for the representative? Seeing none, thank you.
Okay.
Have a good afternoon. Representative Ned Gordon. Speaking in favor of the bill. Good afternoon.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Ned Gordon. I represent Grafton County District 9. I think more importantly, though, I'm appearing as the vice chair of our Grafton County delegation. We are working very diligently in Grafton County on creating a broadband backbone to serve every community in our county and to be expanded on to other counties if in fact that were to work out. But it's important that we take advantage of federal funds in order to be able to do that. I also serve in another capacity. I've been the town moderator for 27 years and the school district moderator for 27 years, and I've done more than my share of special town and school district meetings. And if you have been involved with those, you know that they come with lots of angst, sometimes trauma, and more importantly, delay. And this bill seeks in part to correct that so that while the money's available, we can have a special town meeting without going through the formalities of that process and without that angst. I support the bill wholeheartedly. I think it's something that is needed, and particularly to make our use of federal funds in this unique time to take advantage of those funds while we can. And that's my testimony. Thank you very much.
Thank you. Any questions for Representative Gordon? Just one comment just for clarification of those listening in when you talk about that doing this would make the special meetings possible. It's a resource that makes it available to have a special meeting, but it still takes an approval of the town to have a special meeting.
Yes.
I just wanted to clarify that the passage of the bill doesn't mean you're going to have a special meeting.
Right. It does exempt, if you read the first paragraph, as I read it, it exempts the requirement that you have more than half the registered voters vote at the ballot.
Make it easier.
Yes, makes it much easier.
Okay, thank you very much.
Thank you.
And Margaret Byrne, New Hampshire Municipal Association.
Good afternoon. Margaret Burns, the Executive Director of the New Hampshire Municipal Association, and we are here this afternoon in support of Senate Bill 273. Just by way of a little background, this bill was initiated by some communities up in the northern part of the state that are considering forming a communications district under RSA Chapter 43-G. And they're considering putting the question of formation of the district to the towns in March 2022 at their annual town meetings. But what they realized in working with their bond counsel, sort of looking ahead down the road, was that they would have to wait until the next annual meeting, March 2023, to act on a question of a broadband infrastructure bond for the communications district. And so what the bill seeks to do is allow towns in a communications district not to have to wait an entire year to the next annual town meeting, but to hold a special town meeting in between if they're ready to proceed on a broadband infrastructure bond. currently, to raise and appropriate funds, as Representative Gordon was talking about just a moment ago, to raise and appropriate funds, that either must be done at a regular annual town meeting, or it can be done at a special meeting only if you're able to get half your registered voters to come to the annual special meeting, or if you get court permission and you can state an emergency reason for appropriating money outside of an annual meeting. So basically what this bill does is carve out a narrow exemption that would allow towns in a communications district to have a special town meeting just for the purpose of acting on a broadband infrastructure bond, and to sort of expedite that process if they're ready to go sooner than their next annual town meeting. So it's a very modest change. It doesn't change anything about the standard for allowing broadband infrastructure bonds. It doesn't change anything about the requirement for voters to approve bonds, the process for getting a bond, or sort of any of those important protections that are in place when approving a bond at a town meeting. It just would allow the towns to take that action at a special town meeting. I have spoken with Chris Hodgson from Comcast about the bill, and we may have some small language change suggestions after our conversation this morning for the committee's consideration. But I wanted you to know I have spoken with him to get Comcast's input on the bill as well. May I speak to the amendment that was presented as well?
Yes.
The amendment that was presented would essentially expand the bill not just to apply to towns that are within a communications district. It would expand this bill to apply to any town that is seeking to do a bond for a broadband infrastructure project, so that either an individual town or towns within a communications district would be able to act on a broadband infrastructure bond at a special town meeting. So that's the slight change that the amendment would make.
Thank you. Any questions from the committee? Senator Guida.
Thank you, Mr. Chair. Just for the record, are we speaking to Amendment 0050S?
That's correct.
Just wanted for the record.
Yes, thank you.
Further questions? The only one I would have is that I think we all know that special meetings are nowhere nearly as well attended as annual meetings. And when you get into something like a bond for broadband, it can get pretty hefty. So how do we go about justifying that this should happen? I think we all recognize the need, but I think we also have to try to weigh that out with a person's ability to foot the bill on something, because as one of the representatives mentioned, it isn't going to be federal money forever. So how do we go about finding that balance?
Absolutely. That's a great question. It's something that we've certainly discussed in looking at this bill and sort of weighing the importance of moving forward with these projects versus the policy of allowing an action like this to take place at a special town meeting. In the circumstance of towns that have formed a communications district, I think one of the things that sort of works in favor is that the towns within that district have taken a lot of action already leading up to this point to form the district, and a lot of research and planning would have already happened in these communities. So there would be a lot of buy-in in the municipalities that are part of the district to go ahead and to do this project ahead of time, even before we get to the special meeting. So I think that would lead to more voter and citizen involvement already once we get to the point that they're moving forward with the broadband infrastructure bond. So that would be sort of specific to scenarios where there's a communication district already formed and already formed by action of the voters. So presumably there'd be some good buy-in that, yes, not only do they want to form the district, but then they want to move forward with projects that would be done by the district. And a special town meeting still has to be called in the same manner as an annual town meeting. So it's out of sequence, certainly, and people are used to the normal sequence of events with an annual town meeting, but they still have to post the warrant and call the meeting with the same process as an annual town meeting has to be, which should give sufficient notice to the public that there is a special meeting for an important purpose. Additionally, whenever a town or towns are going to consider a bond at a special, well, at an annual meeting or even at a special meeting, there has to be a bond hearing prior to the town meeting. So that also gives voters additional notice about the action on the bond and the ability to speak out about the bond even before it goes to the floor of the town meeting.
Is there anything about this bill? I don't see any mention in here of 4013. So any town that is under official ballot referendum, would this also apply to them?
Yes, absolutely. By amending RSA 31, Section 5, the first section that it amends, that applies to all towns appropriating money at a town meeting, whether it's traditional or SB2. That's sort of the generic permission to raise and appropriate money statute. So that amendment would apply to all towns.
Okay, thank you. Any further questions from the committee members? Seeing none, thank you very much.
Thank you.
And I have no others signed up. Is there anyone else who wishes to speak that has not spoken? Seeing none, I will close the hearing on Senate Bill 273A. I will. Thank you. We'll now open the hearing on Senate Bill 275 relative to Opioid Abatement Trust Fund and recognize the sponsor, Senator Rosenwald.
Thank you, Mr. Chairman. For the record, I'm Cindy Rosenwald. I have the honor to represent Senate District 13 in Nashua. And I bring Senate Bill 275 to you today on behalf of the Opioid Abatement Trust Fund, established in RSA 126A:83. I have the honor to chair this commission. It was established by House Bill 1639 in 2018. The fund was set up as a negotiated agreement by the state and local jurisdictions to be a process for managing what's going to turn out to be millions of dollars that the state will receive over approximately 20 years as part of litigation involving opioid drug manufacturers, distributors, and possibly other entities. The commission has 22 members, represents a wide variety of stakeholders, and we've been meeting regularly for a year. We have agreed on draft rules for dispersing settlement and judgment funds and will soon enter the rulemaking process. A small amount of the money has already been dispersed to some counties and cities. At a recent meeting of the commission, we voted to submit this bill as containing several amendments to the enacting statutes we think will be helpful. It does three things. One, it updates the census reference for distributing the money according to population. When the bill was enacted, the law was enacted, it referenced the 2010 census. So we're already beyond that. We changed the reference to most recent decennial census in line 7 so that we don't have to keep changing the statute every 10 years, but we can distribute the money based on the population as it is updated every 10 years. Secondly, in section 2, we changed the appointment of the member representing county nursing homes. This was a gubernatorial appointment. It had not been made. The commission wanted to make it a member appointed by the Association of Counties. This is a really important voice for the commission, and we believe they will make the appointment. Finally, in section 3, we want to clarify the duties of the commission to explicitly make clear that evidence-based prevention efforts are an eligible use of the money to mitigate the opioid harm. Two other things. Senator Whitley has an amendment that she's going to bring today. The commission met yesterday and we looked at it. We didn't have a quorum, so we didn't take a vote, but we worked with Senator Whitley, tweaked her language a little bit, and there was no dissent towards her amendment, so we consider it friendly. And finally, James Buffetti from the Department of Justice is here. He knows everything about the ongoing litigation and the development legislative history of this fund. So he would do a better job answering questions about where we stand on litigation and what the money might look like. But I hope the committee will look favorably upon this bill. I'd be happy to try and answer questions.
Okay, thank you. Questions from the committee? Senator Guida.
Thank you, Mr. Chairman. Thank you, Senator, for bringing this bill forward. I referred lines 8 through 10 on the page 1.
Mm-hmm.
It says the population of any political subdivision which receives funds under this section shall not be included in the population of the county for determining the distribution to that county. Can you explain the reason for that and what effect that will have?
So I could try, but Attorney Buffetti will do a better job of explaining it. It has to do, I believe, with which jurisdictions had originally filed suit in these opioid litigations, and we didn't want to double count. Any organization or local or county jurisdiction will be eligible to apply for the bulk of the money that comes in. This is really more about the 15% of monies that come in and are distributed locally off the top. Okay. He can do a better job explaining that.
I'll defer to the attorney later.
Thank you.
Thank you.
Senator Hennessy.
Thank you, Mr. Chairman, and thank you, Senator. And let me know if you want me to ask this question of somebody else. In changing from 2010 to 2020 census numbers, as someone who represents a county that has a declining population, I feel as if the monies that the counties have spent over, you can probably tell me better the amount of time that this has been a problem, it doesn't reflect the past monies that counties have spent on this problem by changing the population to the new census numbers. Does that make sense?
Yeah, I think I understand your question. As I said, this is about that 15% of the funds that get distributed without the opioid commission that's got all these stakeholders representing counties, cities, houses of correction, county attorneys. I mean, it's 22 members, and there are 2 legislators on it, one from the House and one from the Senate. So it's really the people who are out living across the state and seeing the effects every day. 85% of the money will be dispersed according to applications. So your county, for example, is going to get its share of that 15%, but then is eligible to apply for 100% of 85% of the money. If, for example, they decide they want to start doing medication-assisted treatment in their jail, and they want to apply for a lot of money because they believe the need is so great, that's perfectly appropriated. But Mr. Buffetti is better able to talk about how we got to the agreements on these numbers in the first place.
Thank you.
'Cause I think it took some negotiating between the state and the counties and some of the cities and towns.
Thank you.
Further questions? Senator Gaida?
Thank you, Mr. Chairman. So I'm looking at, again, line 6 and 7, where the distribution shall occur on an annual basis and based on the most recent decennial census. I'm thinking 10 years is probably a little bit long, and I'm not wondering if we couldn't substitute in there the population is estimated by, I think it's employment security. They do a really good job of updating what the population is by town, I think by county, and certainly by the state. I'm wondering if that might be a more prudent way of doing it, because 10 years is really an awful long time.
I guess the committee would have to decide whether that was what it wanted to do. Mr. Buffetti can speak to the history of how we got to using the census.
Okay, thank you.
Further questions? You mentioned that the nursing home supervisor or designee had not been appointed by the governor.
Correct?
Now, is there any requirement to force those appointing people to appoint somebody?
I don't believe so.
Okay. And
I'm losing my audience.
believe me, nothing you said.
Oh, thanks.
And then you also mentioned that your committee had discussions yesterday regarding Senator Whitley's amendment. Can I confirm that the 0049S, the one that we have in front of us, includes the comments of your committee? Or is
Correct. Yes,
Okay.
what is before you is what the committee worked on with Senator Whitley yesterday.
Great, thank you. Seeing no further questions?
Thank you.
Thank you very much. The chair recognizes Senator Becky Whitley. Good afternoon.
Good afternoon. Thank you, Mr. Chair. Good afternoon, members of the committee. For the record, my name is Becky Whitley. I'm the senator for District 15, including Concord, Henniker, Hopkinton, and Warner. It's good to see everyone. So I'm grateful to bring forward Amendment 0049S, and I'm grateful to Senator Rosenwald for her leading the commission in this discussion yesterday. So in addition to working with the commission, I just also wanted to note that I worked on this amendment with Associate Attorney General James Buffetti, who is here today and can also speak to this work, and Attorney Jim O'Shaughnessy, a school district attorney from Drummond-Woodsum, who is also here, who could speak to the amendment also. So I just wanted to point out a few reasons why this amendment is so important. As Senator Rosenwald said, it did receive a favorable reception from the commission because they recognize that school districts are an integral part of dealing with this overall opioid crisis. So the amendment really recognizes that the ongoing opioid crisis has taken a significant toll, as we all know, on New Hampshire students. And our school districts are really on the front lines. They're seeing those kids every day. Our children, of course, spend the majority of their time in school. And unfortunately, our local school districts are really challenged daily to meet the increasingly difficult behavioral health needs of children that are impacted by the opioid crisis, whose families are impacted by the opioid crisis, while also, of course, supporting the academic achievement of all students. So we know that the opioid crisis has upended children's lives in so many different ways, and sometimes school is the only constant for these children. So in addition to supporting students impacted by the crisis, this amendment allows our local school districts to engage, so this sort of where this amendment melds with Senator Rosenwald's bill. So it gives local school districts the opportunity to apply for funds to engage in very important prevention-based work to prevent further disruption down the road for these children and their families. And yes, of course, to save money down the road by addressing the problem before it becomes a crisis. We know so many of our children impacted by the opioid crisis end up in our state hospital, end up in crisis later down the road because of unmet needs. So we want to interrupt that cycle and try to do some prevention-based work. It's also important to note that the amendment adds a school administrator to the commission, which the commission also felt was an important way to round out the expertise of the group. So the last thing I wanted to point out is that many school districts already in New Hampshire are engaged in the type of prevention work that we're contemplating here through a framework you might have heard in prior sessions called MTSSB, and that's called Multi-Tiered Systems of Support for Behavioral Health and Wellness. This is not like a program, it's not a particular clinical intervention, but it's a framework, an evidence-based way for schools to do business to support student wellness, and then to connect them with the appropriate community resources from when necessary. And just to connect it full circle, our existing Department of Education already serves as the primary driver for this MTSSB framework under existing statute 135F, which is our system of care law that Senator Hennessy worked so hard on. So it is true that implementation of this framework does require a considerable amount of investment at the local level, but it is completely community driven. So this amendment gives schools the opportunity to request funds through the commission to support this important prevention work. So I'll defer further technical questions, but I'm happy to take any questions from the committee about the amendment.
Thank you. Any questions from the committee? I do have one.
Yes.
On your amendment, line 8,
Yep.
it talks about support for public school programs, and this is the duties of the commission.
Correct.
How does the commission give support for those programs?
So this basically, just adding number 16 gives, there's not explicit authority for school districts to request this funding through the commission. So this gives specific authority under this section 16 to request those funds.
Okay. Why not all schools as opposed to just public schools?
So thank you for that question. It's an important one. And I think that Attorney O'Shaughnessy was going to speak to that in his testimony. Thank you for that question.
Okay, who was that, attorney?
I'm sorry?
Who was going to speak to that?
Attorney Jim O'Shaughnessy.
Okay. Not signed up.
Oh, I think he just signed up.
Okay. All right. Thank you very much. Seeing no further questions.
Thank you.
Have a great afternoon. Chair recognizes Kate Fry, New Futures.
Good afternoon, members of the committee.
Hey.
For the record, my name is Kate Fry. I'm the Vice President of Advocacy at New Futures. We are a nonprofit, nonpartisan organization that works to advocate, educate, and collaborate to improve the health and wellness of New Hampshire residents through policy change. In this role, we work extensively with policymakers, stakeholders, and prevention partners to prevent and reduce the risk of alcohol and other drug problems in our state. We fully support SB 275 because it allows the Opioid Abatement Trust Fund to be used for evidence-based prevention programs and services, including efforts to promote healthy drug lifestyles, reduce isolation, build skills and confidence, and facilitate community and school-based prevention efforts. We are also in support of the amendment that Senator Whitley brought as well, too. I think you heard the history of the trust fund. It was wisely created to make sure these funds aren't diverted elsewhere and they are used to actually address the addiction crisis that we have here in New Hampshire. According to the statute, the department, along with the commission, shall administrate these funds and draw the funds for opiate abatement projects as described under the statute. The projects outlined currently in the statute really just address treatment and recovery efforts, but do not include prevention-based programs. So this bill would fix that. We have heard over and over again that prevention and early intervention strategies can reduce the impact of substance abuse in communities. And fortunately, in New Hampshire, we do have a robust infrastructure of community and school-based prevention organizations. You heard Senator Whitley mention MTSSB, but it makes sense for them to also be at the table to receive some of this funding as well. Prevention is a part of the full continuum of care for substance use disorder, along with treatment and recovery, and such it should be reflected in the duties of the trust fund. I have written testimony for you, and then I also brought some copies of from the Department of Health and Human Services U.S. SAMHSA Focus on Prevention, and it really describes strategies and programs to prevent substance abuse.
Thank you. Any questions from the committee? Seeing none, thank you very much. Chair recognizes Kate Horgan, New Hampshire Association of Counties, supporting the bill.
Good afternoon, Senators. My name is Kate Horgan. I serve as the Executive Director of the New Hampshire Association of Counties. We do fully support Senator Rosenwald's bill and thank her for bringing the bill today. Updating that census data is very important as populations shift around the state. We want to ensure that the funding is going where the people are, so that way we can institute our programs like MAT that are existing in all 10 county jails right now. Also, there was a question about the nursing home administrator appointment. We do have someone who is willing and ready to serve. I can't tell you why the governor didn't appoint someone. We were asked for a volunteer. We gave it to the governor's office, and no appointment has come, but we do have someone who is ready and willing to serve on the committee, and I'm happy to take any questions that the committee members have.
Questions from the committee? Seeing none, thank you very much. James Buffetti. I believe it sounds like a lot has been thrown in your lap.
That's a big buildup. Hopefully I can meet expectations. Good afternoon, Senators. My name is James Buffetti. I'm an Associate Attorney General. I'm the Director of the Division of Legal Counsel at DOJ. And since 2015, I've been the state's lead prosecutor in its opioid cases. There are many cases that are underway. We have a trial to start on February 1st in Merrimack County Superior Court against Johnson & Johnson involving their opioid sales and allegations of deceptive marketing and creation of a public nuisance. So I testified today in full support of SB 275 as well as the amendment that was offered. I was actually the author of that original bill that became that creates the commission and the fund. At the time, frankly, I don't think that I understood or I appreciated that the services that may need to be offered to children who are suffering from opioid use disorder and any co-occurring substance use disorders, or who are from families that wasn't provided for. I actually thought it was. In conversations with Attorney Jim O'Shaughnessy, he pointed out, and he represents school districts who filed lawsuits against opioid companies, but he pointed out that there wasn't any language in the existing legislation that would permit school districts from doing those kinds of grant applications to the commission to provide services for students with opioid use disorder or have families with opioid use disorder. One of the principles of this entire litigation is that all of the money that is going to be received be used for opioid abatement purposes. It's going to be required from the bankruptcy court in the Purdue Farmer case, but it's also written into a lot of these settlements. So we wanted to make sure that the monies that were coming in to any jurisdiction, so city, town, county, the state, goes into an opioid abatement trust fund, and that money be used for opioid abatement purposes. The original statute had 14 approved uses. The bill before you adds 2 more. We are fully in support of that. And I think, as Senator Rosenwald so correctly said, there's going to be money that is going to be coming in from these settlements for at least 18 years. And I can't tell you how much because some of these cases haven't been resolved, but it's going to be millions of dollars that will come in. The hope is that all of this money can be used to abate the opioid crisis and to stop people from dying as they are dying every day in this country from opioid overdose. So I know there were some specific questions about how this works. I'm happy to try and help you answer those.
Senator Hennessy?
Yes, thank you, Mr. Chairman. Thank you for taking my question. I represent Cowas County, is one of the counties I represent. And I imagine that they have been dealing with this crisis for a long time now when their population used to be higher. So my concern would be that the date change of the census to the most recent decennial would not reflect the costs that have already been spent.
So this case has always been about abatement and not about damages. So, damages addressed past harms that were done. We are never going to get enough money to pay back for what governments have paid to address this opioid crisis in past years. We're just not. This is a forward-looking settlement. All of the money is looked for as abatement. So how do we stop the crisis from happening next year and the year after that? So it was never designed to reimburse people for prior expenses and prior damages. What it is designed to do is to provide a source of money to any political subdivision in the state who can come to the commission and say, we have a need, and the need in Cowas County is going to be different from the need in Hillsborough County. But we would encourage Cowas County to say, this is what we need in this county, and to apply to the commission for their share of those funds. And we want to make sure that the funds are given out equally according to the need, so that every political subdivision, no matter how small the city or town or county, has an equal shot of coming to the commission and asking for their share of those funds.
Thank you.
Senator Gaida?
Thank you, Mr. Chairman. Typically, in the history of our drug treatment stuff, okay, the prevention end is underfunded and underattended. And the treatment is emphasized and funded largely with the bulk of the dollars. I'm wondering if it would be appropriate to stipulate a percentage of these funds that must go to prevention, given that that has been, so to speak, the bastard stepchild for a very long time.
Well, I would say this, that there is this structure now in place with this commission, and it's a broad-ranging commission with people from county government, city, treatment facilities. I would say we should let that commission work and do its job. And so as funds come in, we're going to invite grant applications. And so it sort of depends on what the needs are. In my opinion, and this is just one person, but in my opinion, in opioid addiction, one of the most successful ways of dealing with it is through medical assistance treatment, Suboxone and those line of drugs, all right? That's been proven by the science to have the most effect. So that should get, in my opinion, a top priority. But there are other services that could ebb and flow over time as the circumstances change and as this crisis changes. So I would be a little hesitant to say we're going to, at this point, prejudge and make decisions about certain amounts of money going. We know the money has to go to opioid abatement, and all of it has to go for that. And so as the circumstances change and as the nature of this crisis develops, I think you probably want your commission to have the flexibility to be able to make good decisions. And by the way, I should add that the commission makes recommendations to the governor and executive council. So we're not the final word, but we may make recommendations that would be changed by the governor and executive council over time. But I think we need as much flexibility as possible to address the crisis as it develops over the next 18, 20 years.
Thank you. Further questions? Senator D'Alessandro.
Thank you, Mr. Chairman. Attorney Buffetti, nice to see you.
Nice to see you too,
a
Senator.
man whose name ends in a vowel.
I
Thank
agree.
you so much. Just one query. The Purdue case was thrown out. The settlement was thrown out.
Yes.
So that to me is
So-
sort of.
Excuse me, Senator D'Alessandro, can you move your mic straight down?
Sure.
If you have a mask on,
Okay.
it's really coming
Sure.
off garbled, so.
Okay, thank you. The case that's been thrown out, that'll be relitigated, I'm sure. So what kind of money are we talking about at this point in time from other cases coming into the state?
Okay, so it's a little hard to predict, but I can give you some rough estimates. So there are a number of tracks of cases. We, in the AG's office, filed lawsuits against a number of manufacturers and opioid distributors. There were 3 major distributors: McKesson Corporation, Cardinal Health, and AmerisourceBergen. There are national settlements in some of these cases, and so there is one with the 3 major distributors. It's a $21 billion settlement over 18 years. And so we're in a process now of getting sign-ons from New Hampshire cities, towns, and counties to join that settlement with us. We've agreed to join. If that settlement, and if we get maximum participation, my estimate is we will get somewhere around $115 million over 18 years in that settlement. But there'll be a regular flow of income to the state from that. That's just one settlement. Now, you mentioned Purdue. That case is very much up in the air, and if you're interested in these legal issues and bankruptcy issues, this is a fascinating case. I don't know what's going to happen, but the deal that was on the table before it was rejected by the U.S. District Court, if that had gone through, we would have received, I think, somewhere around $22 million over 9 years. We have a case against J&J, and so I can't tell you what's going to happen with that. We're going to take it to a jury, and we'll see if we're successful, and if we get a judgment, it'll be up to Judge Kissinger to decide if we're successful, how much of a judgment to give the state. There is another case involving a manufacturer called Mallinckrodt, and they filed for bankruptcy. It's a much less controversial bankruptcy case. That case is working its way through bankruptcy court in Delaware. If that all works, which I think it will, we should get maybe $10 to $15 million from that case. And as Senator Rosenwald said, there are other cases, there are other manufacturers of opioids. We have not sued them yet, and there are also cases against the major pharmacy chains like Walgreens, Walmart, CVS. So I think this is going to be an ongoing litigation effort, and there'll be payments that will come in, I think, on a regular basis from a number of these settlements over the years.
Further question, Mr. Chairman? Thank you. Now, Jim, how much outside counsel are we using as far as the litigation of these cases?
So for the J&J case, we are relying heavily on outside counsel. I am the attorney at DOJ working on this case. I have been making every decision and involved in every aspect of the case. But we'll have a team of 10 lawyers, outside counsel lawyers, who will be here in Concord helping me to try this case. So to be perfectly frank, we could not do a case of this magnitude without relying on outside counsel. We just simply do not have the resources. There are millions and millions of documents. In the J&J case alone, we've done 70 depositions. We've exchanged millions of documents that all had to be reviewed. We have filed hundreds and hundreds of pleadings and litigated a lot. This has been a very active case, and that's just one case. So we have, out of necessity, relied pretty heavily on outside counsel.
One further question, Mr. Chairman.
Follow-up?
So, and what's the cost of outside counsel?
Well, so the counsel we have is contingency fee counsel.
Yes, right.
So, in the McKesson case, that's that national settlement, $21 billion. In addition, so as part of that settlement, there is a separate fund that would pay for the attorneys, and to draw from the fund, they would have to waive their contingency fee contracts, and they would draw from that money. So that was built into the settlement. So it wouldn't cost us anything. Whatever we get, it wouldn't cost us anything. In the J&J case, that there would, if we go to a judgment, there we would have to pay for their costs and fees because of the work that they did. And I can't tell you what that's going to be. I can tell you that the cost of doing a case like this, expert depositions, is substantial. It's just substantial. But that would be built in. So if we got a judgment, we would ask that the court assess attorney's fees and recover that through a judgment.
Right.
But again, if we're not successful, then we don't pay anything.
Right. Okay. Thank you, Mr. Chairman.
Thank you. Further questions from the committee? Seeing none, thank you very much,
Thank you,
Mr. Buffett. Chair recognizes Jim O'Shaughnessy.
Good afternoon, Senators. Thanks for speaking with me today. My name is Jim O'Shaughnessy. I'm an attorney at the Drummond Woodsum Law Firm, and I exclusively represent schools, public schools, private schools, charter schools, and child care centers in New Hampshire. So this is my area of practice. My law firm works actually with National Counsel. We represent 5 school districts throughout New Hampshire that are part of the plaintiffs' class involved in all of this litigation. I'm local counsel. I really know even like a percentage of what Attorney Buffetti knows about the ongoing litigation. But what I will say is that school districts were very much late to the game in joining this litigation. They weren't really seen as the original class of people or groups that were harmed by the opioid epidemic. But as time has rolled on, we've recognized that there are kids in schools whose parents have abuse disorder, students who have opioid use disorder, and it's just prevalent in the schools right now. We're providing special ed supports and services to these students. So we're part of the plaintiffs' class. We are part of the group that has to sign off or has been asked to sign off these settlement agreements. We've also recognized that there's a limitation. We are a political subdivision. This is not a home rule state. We know that, and we have an abatement trust that says 85% of the money that's available can only be available for specific uses. School districts and prevention for schools is not one of the uses. I recognize this in conversations with Attorney Buffetti. So we've worked with some of the senators here to try to get the trust document amended. So school districts would have the chance to apply, put a plan together, a group of districts, say in Coos County, to put a plan together and apply to have access to some of this money. Because they are plaintiffs, they have actually been harmed. The courts have recognized that they've been harmed, and they're part of a class of plaintiffs that are potentially going to potentially be awarded damages. So in that sense, we think it's appropriate to add school districts, and we think as this rolls out over the next 10 to 15 years, we don't know what it's going to look like, but we certainly think prevention is going to be a priority, and that's all happening at the schools. If I may, I just want to touch upon a couple other points. What distinguishes this from why other schools wouldn't be eligible is other schools, first of all, aren't members of the plaintiffs' class. This is all political subdivisions. Cities, towns, counties, and public schools are the harmed individuals recognized by the courts. They're not, private schools and private nursing homes aren't part of the litigating class of plaintiffs in this case. And also, private institutions aren't limited by the state law. The state law is what limits school districts' ability to actually collect their own damages from this litigation. It automatically goes into the trust, so they can't get any funding unless you amend the law, basically. I really think that's it. I'm happy to answer questions if folks have questions.
Senator D'Alessandro.
Thank you, Mr. Chairman. Based on what you just said, school districts have already laid out money to treat this problem, right? They've, through special needs, special education, and other situations. So are you telling me that at this point in time, they can't recover what they've spent?
I think it's similar to what's happened across the state. Everyone's expended money trying to deal with the opioid epidemic in a variety of different ways. Now there's going to be money available to try to sort of right the wrong. It's not recovering money already spent. It's to treat it so we're sort of correcting it for the future. So I wouldn't say, I don't know, but I don't think school districts have put together, like across the state, a plan to address opioid, the opioid crisis. I think that would be sort of a new thing. This would give them an opportunity to do something like that.
Further question? But it seems to me they're all suffering
Yes.
from this situation. And it would seem to be rather inconsistent in my thought process that you haven't developed a plan to deal with this, particularly when pharmaceuticals are accepting the responsibility one way or the other, by the fact of the matter is we're all going to court with them. So it just seems to me that we're like a day late and a dollar short, and that bothers me. I've been in education all of my life, and boy, that's very, very, very concerning. I'm very concerned about that.
Yeah, I actually join you, and that's like I've been sort of very loosely involved, and when I recognized from talking with Attorney Buffetti, when I recognized that there was no school access and there was really no prevention at all in the current uses, that just blew me away. So I think it's how this all started, and now we're recognizing it needs to be tweaked a little bit to really work correctly, but I completely agree with you.
Thank you, Mr. Chairman.
Senator Hennessy.
Thank you, Mr. Chairman. Thank you for coming before us today. So on the amendment, and I'm not sure if you have that in front of
Yes,
you.
I do.
Okay, so line 8 on the amendment where it says support for public schools, that doesn't, that includes all public schools, including public charter schools, correct?
Yes.
Okay, thank you.
Further questions? I have okay, Senator Gaida.
Thank you, Mr. Chairman. Senator Henderson comment raises the question, what about other schools in public?
Other schools aren't political
They're
subdivisions.
not political subdivisions, therefore
Yeah.
wouldn't be eligible for assistance.
No, they're not. They're not covered by the trust, so they wouldn't be allowed to apply for that.
Is it too late for someone to become a plaintiff?
At this point, there are, like Attorney Buffetti said, there are new cases that are being brought against like new distributors. And so in some of those cases, there may be an opportunity for additional plaintiffs, but in the current cases where the settlements are being discussed in the bankruptcy litigation, my understanding is that it's too late.
Okay. And I heard the testimony that districts were late getting it. Why would we do a district by district as opposed to, say, the Department of Education being the sole one putting it in on behalf of all the districts?
To be honest, I think this is the simplest way to allow school districts the opportunity to come up with their own plans that work for their own communities, and to ask the commission for for a little bit of funding to support that. I think the commission is really a group of experts who have put a lot of thought and time into this, and so I think the idea is school districts reach out to the commission and say, we're looking at this type of program in Coos County or Rockingham County or Manchester or Nashua. What are you looking for? And we would really be deferring to that group of people who are, and of course Attorney Buffetti, who have put a lot of time and thought and energy into this. It's really just like anything else, it's the easiest solution. Allow school districts to apply to access some of the funding in the trusts. And every school district and every charter school would be eligible to apply.
Okay, thank you. Seeing no further questions, thank you very much.
Thank you.
That was the last person I had signed up. Is there anyone else who wishes to speak? Before we close, I do have a question for Representative Rosenwald as chair of the commission. Does the commission put out an annual report?
Let me look at the enacting statute. I know the cities and towns are required to report annually to the commission how it has, how they've spent their funds. So that's in section, well, in the enacting law, by September, every county, city, town, or program that receives funds has to provide an annual report. Yes, and then every year beginning November 1st, 2020, the Commissioner of the Department of Health and Human Services shall submit an annual report to the Governor and Fiscal Committee of the General Court detailing the activities of the Advisory Commission, the administration of the Opioid Abatement Trust Fund, the amount distributed in the past year, the amount remaining in the trust fund, a summary of how funds were used, and any recommendations for future legislation. We didn't begin meeting until after that date, I think, so we have yet to put out, I believe, an annual report, but that is required.
Okay, because you kind of captured some of the tenets that I was looking for in the report, like the amount received, how it's been used. One thing that didn't seem to have, or I didn't hear it, was a measurement of success. How are you determining whether the money that you're giving out is you're successful with that, or we're just throwing money at a problem that is not getting solved?
So one of the members of the commission is the chair of the Governor's Commission on Alcohol and Drug Prevention, Treatment, and Recovery, I think it's called now. And the county prosecutors are represented, the county jails are represented, some large counties, small counties, commissioners are appointments. We would not be service providers ourselves. We would be awarding grants to governmental entities and nonprofits that actually would implement the programming. They are, I think, better suited to report on their outcomes to their boards that govern them, but I mean, I don't see any reason why we couldn't
Okay, I know
ask.
I know
for
it's a
that.
common question that you and I and Senator D'Alessandro, anyone who's been on finance have constantly asked.
Right, how do we know
DHHS
this
is
works?
how do we know that what we're spending the money on is being
It's
successful?
working.
So,
Right, so, I mean, when we were in the House and served on our county delegations, if our county jails wanted to do drug treatment programs, I know we were asking, what's your measurement of success? I think those questions are being asked all the time at all levels, but there's no reason we couldn't add a section to the annual reports that cover
I think it would be helpful for those reading it, so all that information is in one place, rather than having to look at maybe 50 different reports.
I would consider that a
Okay.
friendly amendment.
Okay, thank you. Seeing no further questions, I will close the hearing on Senate Bill 275. Okay. Okay. Sure will. We will open the hearing on Senate Bill 276 and recognize the sponsor, Senator D'Alessandro. Good afternoon.
Good afternoon, Mr. Chairman. And, excuse me, and distinguished members of the committee. For the record, I'm Senator Lou D'Alessandro. I represent District 20, Manchester Wards 3, 4, 10, 11, in the town of Goffstown. And I come before you as the prime sponsor of Senate Bill 276. I'd like to give you a little history as to the impetus for this piece of legislation. In 2018, Dean Kamen came before this legislature and this finance committee and asked for a very specific exemption, an exemption to the business profits tax and the business enterprise tax for a period of 10 years. The rationale was this advanced manufacturing business was going to create a tremendous amount of activity in the scientific community because it had to do with creating organs. The Department of Defense was the prime sponsor of this initiative. I think they gave Dean Kamen $80 million the first go-round and another $20 million the second go-round. And he's put together a consortium of others, about 250 entities, that have bought into this tremendous project. But the fact that we gave them 10 years with no tax, business enterprise or business profits, was really something special. And this legislature debated long and hard before we, in terms of inventing, creating artificial organs, and what effect that would have on the lives of human beings. And I relate that just yesterday, an artificial heart was placed in the body of a human being. This artificial heart was grown in an animal outside. It was a pig's heart, was transplanted into this human being. Human being was going to die. There was no chance of a heart transplant. So recognizing that and recognizing how important this legislation was, and because of the importance of developing this regenerative manufacturing. And the stipulation was only companies associated with regenerative manufacturing could get this exemption. And this exemption would last for 10 years. Now, I've tried to follow this by visiting the company and querying those at the company as to how far we have gone in terms of the development of this technology. Now, I was told at my last meeting that they were working on the heart, and they were doing some very innovative and creative things with regard to hearts. We all know about heart transplants and how difficult that is and what happens when you receive a transplant, the rejection medicine that has to be provided for you. It's very expensive and it's a long, long process. So I thought it was imperative that we, this legislature, the President of the Senate, the Speaker of the House, the Governor, get an annual report on the progress that's been made with regard to this manufacturing. We gave them a very, very extraordinary exemption. Extraordinary exemption. And we did it, I think, for two reasons. One was we knew that this type of research activity would be very beneficial to the world, but certainly very beneficial to New Hampshire. Located in the middle yard of New Hampshire, this creates a tremendous opportunity for research and development. But it seems to me we, the legislature, should receive an annual report on how much progress has taken place, what's happened, and how far they are with regard to the development. And that's why I proposed this legislation. I was on the committee. I think others were on the committee. I think Senator Gardner, you might have been on the committee when we passed this. Senator Reagan was on this committee. We all thought it was a wonderful thing. And it seems to me that just an annual report on the progress of this regenerative manufacturing business would be good for us. It would be good for us to look at, good for us to recognize how far along this situation has become. I did meet with the people at DECA. I did say I was going to propose this legislation. They had no opposition to it. They thought it would be a good idea, and I think the legislature deserves a report. We made a really a very important decision, and we should be able to follow how well this decision was carried out and how well it's progressing. So with that, Mr. Chairman, I thank you so much. I thank the committee. I hope they'll act favorably on this piece of legislation. I think it's important to New Hampshire. And they're building labs in the mill yard. That's important. The University of New Hampshire is working with them in terms of lab use, and students who are in graduate degrees are working with them. And there's also an opportunity for this company to bring very high-tech people to the area. Very high-tech people who would be interested in becoming involved in this process. So I thank you, and we'll be happy to answer any questions that you might have.
Thank you. Any questions from the committee? Senator Gardner?
Thank you, Mr. Chairman. Thank you, Senator, for your testimony. Did you perchance speak with James Q. Wallace, Executive Director of the Business Finance Authority? Maybe they already have this and we don't need to pass a law to get this?
I haven't spoken with him about this in particular, but I know that workforce development was part of this bill, and he was involved with that, the Business Finance Authority. But I'm not sure that they deliver an annual report. I could query that and ask if I could follow up on that if you like. I will follow up on that.
Okay. And
Follow-up?
so would you report back to the committee?
Yes.
You know, what your conversation? I know he's very, very effective as
Yes.
executive director over there. I sit on that board,
Right.
and I'm happy to convey the question, and I'm sure that he'd
Sure.
be more than happy to answer. I'm not sure, whether we need to legislate this
Yeah.
without even asking the folks that are
Sure.
involved.
That's a good point. Yes,
Thank you.
sure. Happy.
Senator Hennessy?
Thank you. Thank you, Mr. Chair. Thank you, Senator. So the way I read the bill, the report should already be delivered every 6 months to the fiscal committee. Is that report not coming? I don't know what the original effective date for the original legislation was.
Well, there've been no reports at this point in time. I've been on the fiscal committee for a long time. We've never had a report.
Follow-up?
Follow-up?
So by adding the Finance Committee and the House Finance Committee and the House Senate Finance Committee, how would that encourage them to deliver the report if they haven't done it yet?
Well, this would tell them that they must give us a report. And since both committees were involved in the acceptance and the favorable vote on this piece of legislation, and I think it does have an impact. It's going to have an impact on revenue when you think of the fact that you've eliminated from the business profits tax and the business enterprise tax, in 10 years of any activity in that area.
So how late is their first report? Do you know when they were supposed to deliver their first report to the
Well,
fiscal committee?
let's say the bill went into effect in 2019. I would think that would be the time. So this is 2022. So I would think they're a couple of years behind.
Thank you.
Further questions? Would it be wise where we put in there a 6-month period to define when those reports are due? And that, we might set dates that are advantageous to the legislature to take action on something if it needs to be done?
Sure. Thank you for the comment. I think anything that effectively gets the reports coming in a timely manner makes a great deal of sense.
Okay, thank you. Senator Guy.
Just a question, if we're concerned about revenues, would this not be more appropriately put in the venue of the Ways and Means Committee? That was the committee of referral for the original bill.
It was Ways and Means that made the decision. That's correct. Yeah, I don't have any problem with that. I just think that the report's the thing that's of most importance to me, because it has a dual effect. It not only affects the revenue, but it affects the progress of what I think a tremendous research project that could affect the lives. Now, look, at the military was very interested in this project because of the naming of soldiers that are on the battlefield. And if you could regenerate kidneys, hearts, limbs, you're talking about a tremendous benefit to the troops, but an enormous amount in terms of savings. Because when you look at what the medical costs are of maintaining individuals who have been wounded, I mean, those costs are enormous, and they're forever. They go on for the entire lifespan of the individual. So I have no problem with it going to Ways and Means. I think I just think a report to the appropriate committee is the essential thing.
Thank you. Seeing no further questions, thank you very much.
Thank you,
Is there
Mr.
anyone
Chairman.
else who wishes to testify on this bill? Seeing no one, we will close the hearing on Senate Bill 276. Okay. We'll open the hearing on Senate Bill 277 relative to emergency or temporary health care licenses and recognize the sponsor, Senator Hennessy.
Thank you, Mr. Chairman. Thank you, members of the Senate Finance Committee. Aprn Hennessy, I'm the state senator for District 1. I am here to introduce SB 277FN, which is a reintroduction of the very important healthcare license, emergency healthcare licensing bill that was passed by our body from Senator Bradley, SB 155. And what this does, it extends out the period of which our Office of Professional Licensure can grant emergency or licensing, or I believe they can do certificate things as well. But what it's done over the past, since the pandemic when this started, was brought 22,000 individuals who were not previously licensed in New Hampshire into an emergency licensing status. And I handed out a spreadsheet that I received from the office, from Executive Director Courtney Lindsay, that shows where these healthcare individuals fall in what kind of healthcare practice that they do, and how many individuals have come into New Hampshire or are maybe helping New Hampshire individuals. And the Executive Director should be here to go into details about that if you have any questions. This extends it to January of 2024. One thing that I might note is that the executive has proposed an amendment to this legislation, and I also put that in front of you. So if you have questions, I'm sure she can go into details and explain that. So I will be happy to have her come up and answer any technical questions on this. But I think we all know how important this has been for New Hampshire, given how difficult it is. It was previous to the pandemic to find healthcare providers, and now, especially during the pandemic, finding healthcare providers. So this is an important thing that can possibly help set New Hampshire up when we get through this pandemic for a very successful healthcare environment post-pandemic.
Thank you. Any questions from the committee? Senator Guida?
I'm not sure, Senator, that you might have an answer to this, but have we had any adverse, any problems from out-of-state licensees performing in our state? My concern being, for looking at the amendment, extending essentially permanent status to people that might have been problematic in their service.
Thank you. That's an excellent question, and I'm sure the executive director can go into that. But based on the conversations that I had with her, she noted that they've had 2 complaints out of the 22,000. And I don't know if those were founded complaints or not.
Thank you.
Thank you.
Further questions? Seeing none, thank you very much.
Thank you.
Chair recognizes Kate Horgan, speaking in favor.
Good morning, good afternoon, Senators. My name is Kate Horgan. I serve as the Executive Director of the New Hampshire Association of Counties. In this case, your 11 county nursing homes. The association is in full support of this legislation. As you know, the COVID pandemic did greatly affect our workforce and our ability to staff. Some of these temporary healthcare workers were life-saving workers for us during the pandemic, at the height of the pandemic. So we would be fully in support of extending their licenses to 2024. And to answer the question, I know there have been 2 complaints, but as far as I know, none of those complaints were in county nursing homes. I'm happy to take any questions.
Any questions from the committee?
Thank
Seeing
you.
none, thank you very much. The chair recognizes Dr. Debbie Warner, speaking in favor of the bill.
Good afternoon. Thank you for having me at your presence here. Greetings to the Finance Committee and the Senate, the Senators, Mr. Chairman, and all of you. Appreciate this opportunity. I'm Dr. Debbie Warner. I'm from Littleton. I am representing the Board of Psychologists, which is one of the professions that would be affected by this bill. The board is in favor of the legislation as written. We would like 2 more years for these emergency licenses. And the reason for that is because we have, in this interim time during COVID, we have put together, and it was passed, a telemedicine license for our psychologists that was in the works even before COVID, and we brought it completed in that time. We have a quick entry to that license, and we are in the rule development stage of that. It does involve a jurisprudence exam, and that's under development as well in an RFP process with the Office of Professional License. And this would give us time to get our rules all put together and smooth and streamlined. To have 2 years to do that, I think is quite sufficient. 1 year might be fine, but 2 years is just very nice. The amendment that was on the table that I saw, the board is not in favor of such a thing as this amendment because it's just simply rubber stamping anyone with an out-of-state license to get a full license in the state. And all of the boards have their own different ways of dealing with out-of-state licenses. In our profession, we have a smooth track, an easy track for people with out-of-state licenses who have certain national credentials where their education and training has gone through some filtering there, and we know how they are trained. It is possible to get a doctorate in psychology and not have had the standards that the profession would require in general. We require an internship. We require a 2-year residency. We require certain structure of the courses during their doctoral time. And it is possible to go to certain schools that are not approved by these credentialing, national credentials, and receive a doctorate with studies in developmental psychology and social psychology and some other various interesting things, experimental psychology, that are not applicable to your clinical skills needed to help people reliably in the field. And that is why we have licensure altogether, is so that professional standards are maintained. So the board is quite against this amendment, and I believe the other boards would be as well if they knew about it and they were present. I think that it might do some good for the OPLC division to give them, take on all the different boards and form a committee and find out what would be an easier way to have some quick national certification or respond to national certification in all of the different disciplines so that it could be easier and streamlined. But this is not it, and this is quite against the standard of care that we expect to be delivered in the state of New Hampshire for psychologists, and I do believe for the other disciplines as well, although I'm not authorized to speak on behalf of the other boards.
Thank you. Any questions from the committee? Senator Gaida.
I have two. Immediately as you're speaking, two things came to mind as potential amendments to this amendment. First would be, I think, more appropriately to Senator Hennessy's, and that would be that if a licensee has had a complaint, if that complaint has been adjudicated and found against the licensee, that person would not then be extended, pending some remediation process by the relevant board. And the second would be relative to your specific concern, if the licensee qualifications are at least equivalent to the standards established by the relevant boards in New Hampshire.
Yes, however, there is a lot of gray area in that regard, and while the statute does say that the OPLC director would consult with the boards to find out which states are equivalent, it doesn't say how they're examined. And these would be simply administratively handled. They wouldn't be reviewed by the board. In our board, when somebody doesn't meet those national credentials that are part of our rules, they're not in our statute, that's our fast track. And if they don't make that, then we go through the regular review process. People have to go through essay writing, and they have to be reviewed by the board. This would completely go around all of our safeguards.
Are your guidelines in writing?
Our guidelines are in writing. They're in our rules, but they're not in statute.
Follow-up? So if they're in writing and OPLC administratively notes that the qualifications you establish in your standards are met by the individual who is basically the temporary licensee who's going to get permanence, okay, why would that be objectionable?
Because there are, even in the ones that do come up, there are things like older complaints that have been satisfied. We need to review them to see how severe they are, whether or not they would continue to hamper someone's practice, whether we would have doubts about their safety practicing in New Hampshire. We do have a board that does review that.
Thank you.
Further questions? Senator Rosenwald?
Thank you, Mr. Chairman. Thank you for taking my question. I noticed when I look at the table that we have more temporary licensed psychologists in New Hampshire than permanent licenses. Does that suggest that we don't have anywhere near enough psychologists who are licensed and practicing here?
Well, although those emergency licenses were granted, we do not have any idea of how much volume they are doing, whether or not all of them are even seeing patients in New Hampshire. They may have, and we don't know how many patients they see in New Hampshire. So to judge how much of our volume of psychology delivery is happening with that 1,000 people extra, we're not aware of that. When this first came about, there were approximately 500 licensed psychologists, and we quite quickly got 500 licensed school psychologists joined into our board. And then the pandemic came, and executive order brought in anyone who had a clean license in another state got that emergency license. The board was not consulted on how that happened. And the board generally does a very, very careful job of developing rules and developing a good course of scrutiny so that the people who are practicing in New Hampshire are going to be safe to practice.
Further questions? Seeing none, thank you very much.
Thank you.
Chair recognizes Lindsay Courtney.
Good afternoon, Mr. Chair, members of the committee. My name is Lindsay Courtney. I am the Executive Director of the Office of Professional Licensure and Certification. I've submitted in advance some written testimony as well as the chart that was previously provided to you by Senator Hennessy. Essentially, OPLC supports this 100% as written. As you may recall, when we first started initially issuing emergency licenses, it was in anticipation that it would only be for a couple of weeks, and unfortunately this has persisted. And we now have over 22,000 healthcare professionals who have emergency licenses. Right now, given our healthcare workforce shortage, we don't think it's time to shut them off. We did promulgate an emergency rule I think it was 2 weeks ago, that would effectively convert the existing emergency licenses to a temporary license so that those licenses don't expire until May 31st. That'll give us a little bit more time to figure out what to do with them. But as of right now, there's nothing outside of a statutory amendment that would allow us to continue these emergency licenses. We would recommend, in lieu of just extending them out 2 additional years, to actually convert them to permanent licenses. And the reason for this is really twofold. First, administratively, it's become quite difficult to keep track of who is actually practicing and who actually of the 22,000 is actually working in New Hampshire. Many people obtained emergency licenses quite immediately because we issued them in about 24 business hours, and then went on to apply for permanent licensure. But the way the data is collected in our licensing portal, there's absolutely no way to compare the 2 data sets. So we don't know how many people of the 22,000 actually need the licenses. The other aspect of this is that we started issuing these emergency licenses in March of 2020. In January 2024, it'll be almost 4 years. Most licenses are on a biennial renewal schedule, meaning they have to renew every 2 years. They have to be re-reviewed. We make sure that they've completed continuing education requirements. If we were to extend these an additional 2 years, that would be 4 years, obviously, without having been reviewed. It forces the licensee to take an affirmative step of renewal, and so then we know actually how many people do intend to stay in New Hampshire. We have received only 2 complaints. We have not had any adjudications out of the 22,000. Partly that could be because many of the licensees were here on a transitory basis. We're using a lot of traveling healthcare workers that may only come for 3, 4-month assignment, not sufficient time, hopefully, to commit misconduct. But we have not had any adjudications. The concerns regarding, I do want to address, even though this licensure bill is not really intended to address the statewide portability problem, but we do have a portability issue in the state in terms of how our licenses are, how licensees in other states are able to obtain licenses in New Hampshire. Certain boards are on top of their game. Board of Nursing is one of them. I would say that we have a quick, easy way to obtain an endorsement. Other boards are not so easy. And I think the numbers that you see in the chart reflect which boards actually have portability problems, and it's typically the boards that have higher percentages, with the exception of physicians, because there were some bulk submissions going on. So in any event, I think that's the right approach. Force the licensees to make an affirmative decision about whether they want to stay here. Force them to continue to meet the requirements that all other licensees have met. There's been 2 years without significant discipline, and I think if you've had a license in another state and you've practiced for a certain period of time, we should allow you to practice in New Hampshire. I really don't think that that's should be a controversial issue. I'm happy to take any questions.
Thank you. Any questions from the committee? Senator Rosenwald.
Thank you. I have 2 questions, or 1.5 questions, if I could. Am I to understand that the reason somebody wouldn't be practicing without a license is because you would convert as of the end of this month to a permanent license, all those thousands of emergency licenses? Could you do that in a month?
Yes. So what we would do is whatever the effective date of the bill, if this bill were to be amended and to go through, on the effective date of the bill, we would treat the date of the bill as the date of initial issuance. And then whatever the board rules are for that particular profession regarding renewal, that's what would govern what their renewal date would be. So essentially, most of them would get another 2 years before they had to renew in accordance with the board requirements. So Board of Nursing, they renew in their birth month on their birthday, but psychologists are June 30th of a certain period of time. So that's how we would determine what the date of renewal would be.
Follow up. Thank you. So if this bill didn't get signed until June 30th, between January 31st and June 30th, these people would not be licensed?
No, we promulgated an emergency rule per our statutory authority in RSA 310A. And what we did was we converted the existing emergency licenses, the 22,000, to temporary licenses. They will expire May 31st, and there's nothing else I can do at that point.
Okay. My second question, if I could, is about the fiscal note. So if this bill passes, you're going to lose almost $700,000 of revenue in this year and then make it up 2 years from now. What's that going to do to OPLC's budget? Can you manage your workflow given $700,000 less in the biennium?
Yes, I'm not concerned about the funding because these licensees have had a license without paying anything for it for the last 2 years. These are people that we were not anticipating going to be licensed at some certain point in time. Our justification for the fiscal note is that if they were to expire, arguably a certain percentage of them would have sought permanent licensure and would have paid the fee. Whereas if you were to extend the expiration, just simply extending the expiration date, we won't collect that fee. but our budget is based on our projections for licensure numbers that don't take into effect the 22,000.
Got it. Thank you.
Further questions, Senator Hennessy?
Thank you, Mr. Chairman, and thank you, Executive Director, and I apologize for getting your name
Oh, you're
mixed up.
Happens all the time.
So just to build on some of Senator Rosenwald's questions, if the amendment were to pass, those people that would be converted to permanent licensure in New Hampshire, when would they pay the fee? Would they have to pay upon conversion date, or they would have to pay upon renewal date?
They would have to pay upon renewal date. We would treat the date of conversion as the date of issuance of the initial license, and then whatever the board statutory requirements are for renewal, they would likely get close to another 2 years without having to make the payment, depending on where they fell into the cycle.
Thank you. And if, depending on the board, as you said, the continuing education or whatever the requirements of that license are, they would have that 2-ish years to perform that needed requirement as well. Is that correct?
Yes, there are certain boards that there's a handful of them that the statutory framework is such that if you, for example, dental is one of them, if you issue a license in February prior to their April renewal schedule, they still have to renew that April. Those are some changes that we are going to be seeking. Cosmetology is another one that's obviously not subject to this. The large majority of boards, you get almost a full 2 years. It just depends on what the statute says.
Follow up again. So to address Dr. Warner's concerns that some of these individuals may not meet New Hampshire standards, what safeguards might there be in place, or perhaps changes to the amendment that would meet those concerns?
So I think there's so if I may speak frankly, the Board of Psychology, their requirements for obtaining licensure by endorsement are generally way more stringent than other states. So there is a disagreement as to what parameters we could put around because I don't think we've come to a fundamental agreement as to what reciprocity or endorsement should require. If you're a practicing psychologist in Massachusetts, generally you have to file an application that may require you to draft a bunch of essays that obviously can't be reviewed by staff, as well as answer a whole host of questions, provide references. You know, those are the types of hoops that somebody who's been practicing for 30 years just shouldn't have to jump through. So I think that the reasonable solution is to afford the board who has not reviewed any of these emergency licensing applications to review them at the time of renewal. If they are concerned that the person is not qualified at that point, they could hold a hearing and have the person come in and explain why they have demonstrated qualifications for licensure. But these are people already here, maybe practicing, but at least legally authorized to do so.
And just one follow-up. So if someone were to have received their emergency license in New Hampshire March of 2020, we've extended that out. Are there any requirements that they prove that they're still licensed in another state?
No, and that is another area of concern that we have. Once they've initially been licensed, there is no mechanism if they allow their other license to drop off for us to essentially revoke the license because they met the initial qualifications and there's no time frame for us to be reviewing that.
Thank you.
Senator Rosenwald.
Thank you. Following up on Senator Hennessy's question, it sounds like they haven't paid a fee to the board for the emergency license, and they're going to get 2 years before they have to file and pay the fee for renewing their license. Is that unequitable versus the people who want to work here and come and file an application for an original license, don't they have to pay a fee with that application?
Yes, they do have to pay a fee. OPLC fees are have to basically support the operations. And our operations are supported. I think what happened was obviously in March 2020, we anticipated a public health need that the benefit outweighed the concerns for inequity regarding finances, essentially. And right now, the concern is that what I've observed in my office is that people, particularly in healthcare right now, are struggling to follow even very basic directions. Our healthcare workforce shortage is pretty, it's in dire straits. I get calls every day. We need this LNA here. Can you do what you can to make sure that, they get to the top of the pile, so to speak? Sundays, holidays. So my concern is that even if a small percentage of those people didn't read their email that they needed to go in and make a payment, that we would suddenly have many healthcare workers who couldn't practice on day one. And that's something that the office really couldn't, we couldn't administratively support responding to that.
Follow up?
Thank you. But I thought you didn't know how many of them were actually working. Why not just collect the fee on issuance of the permanent license, but say you have, 90 days to pay it or something?
We don't know how many are working. I feel confident that a sizable portion of 22,000, even 100 people, that's a significant for a lot of healthcare facilities right now. Administratively, I would have concerns with that, mainly because it's kind of a nightmare to keep track of 22,000 payments. They wouldn't be able to make it through our existing licensing portal, which is extremely old and ineffective, so they'd have to mail in payments. And then the question becomes, okay, so if they didn't make the payment, now we've got to hold hearings on all of these people who didn't make the payment. Maybe they didn't make the payment because they didn't want a permanent license. So I think the way to handle the payment is usually at the time of renewal. They can make the decision not to renew. If they choose not to renew, their license just goes into inactive status. It's not that we don't want funding in our budget. It's just administratively it would be difficult.
Senator D'Alessandro?
Thank you, Mr. Chairman. I understand that national agencies like the Council of State Governments and maybe NCSL have been working on reciprocity for licenses. It seems to me that would certainly be an aid to you in terms of processing. Is that in effect, or where does that stand at this point in time?
Yeah, so New Hampshire generally participates in all of the compacts to which we're eligible. The only exception is, at least from my agency's standpoint, is the Aprn Compact. The reason we've chosen not to participate in Aprn Compact is because our state APRNs have independent provider status, whereas the Compact does not. It requires supervision. But certainly nursing endorsement, they're part of the Compact. People who have a multi-state license can just come here and work. That's definitely helpful. So we explore every compact that comes to us. Unfortunately, the surrounding states are not, they don't actively participate in as many compacts, and that's where we draw a lot of our workforce.
Okay. One further question, Mr. Chairman. And the traveling nursing situation, that seems to be something that it's troubling. It's troubling to me, and I'll give you an instance. I was in a hospital. I was in the emergency room, and a nurse was working on me. She told me that she was leaving, and she had another assignment that next day. It was a little disconcerting to me to know that the person who was working on me wasn't going to be there to make the final decision. So, is that problematic with the traveling nurses? I mean, do they? What are we doing to address that?
I think that's a long-term goal. I think we need to grow our workforce, home grow our workforce. I think part of the problem, we have people who are from New Hampshire, but they get paid so much at a much higher rate
Right.
to be a traveler. They'll go and accept assignments outside of New Hampshire. And we just don't have, we're just not growing it. So I think that we're trying to focus on, and we're working with the Board of Nursing to really streamline certain application requirements. One thing we're looking at is maybe doing a crosswalk with education to allow paramedics to become nurses. We're looking at other educational opportunities in high schools, not just LNAs, but maybe an LPN program. I think that's what the state needs to start focusing on, because the large majority of our applications by far are endorsement applications. They're from out of state, and they just don't have the ties here.
Any further questions from the committee for Ms. Courtney?
Thank you very much.
Seeing
Appreciate
none,
your time.
Thank you very much. And Dr. Warner, you wish to add to your testimony?
I do appreciate the opportunity to speak again. Thank you. I think that it's important for the committee to realize that although this amendment is quite short, only about 3 lines, it's quite revolutionary in terms of all the boards. It has just come out, and we just went from LSR to bill a week ago, and the boards have not been notified of this. We just had a board meeting on Friday, and we were not notified. We only knew about these things because I had looked these up. And I think that the other 54 boards would be interested in this and would want to weigh in and determine what this is. I looked at the minutes from the medical board, and they do out-of-state license applications every month, and so do we. And I just think it's really important that this amendment be really taken quite seriously and given more time. Whereas I think that the bill is written is quite clear and just extends a situation that happened by fiat and was necessary under the circumstances that we found ourselves in, and will give the department enough time to come up with some of these other things that, if in the long run it is good to find a more streamlined way for administration to deal with out-of-state licenses, if these boards could delegate more of that to the staff and to something more routine, I think that that's worthy of some consideration. But I would suggest that it not be included in this bill that Senator Hennessy would like to see move quite quickly and get a signature so that these things can happen even before the end of the month.
Thank you very much.
Thank you.
I have no other people who are present and wish to testify. We'll say that Paula Minahan of the New Hampshire Hospital Association signed in favor of the bill as amended. Greg Moore from Americans for Prosperity, New Hampshire, in favor. And I'm not sure the next one. It looks like something Director Association representing Robert Clegg. Well, yeah, I don't know what that word is. But he was also in favor. So before we close out, well, actually we can close out the hearing on Senate Bill 277, and I'd just like to read into the record that we have those who testified remotely on Senate Bill 277. The senators Carson, Waters, Gaida, Bradley, Daniels, Gannon, Avard, Birdsell, Rosenwald, Sherman, Representative Tom Bucco, Jake Perry, and Teresa Rosenberger. They all signed in support of the bill. Going back to Senate Bill 273, we had remote testimony from Senator Ruth Ward and Senator Regina Birdsell, both in support. On Senate Bill 275, I'm going to butcher this name probably. Cora Quisumbing King, in support. Senator Susi, in support. Lisa Mascio, neutral. Deborah Narrow, support. And Chris Herring, in support. And finally, Senate Bill 276, Senator David Waters and Senator Jeb Bradley in support. With that, our business on the hearings is concluded today, and we will be in recess until 3:30.
Perfect, thank you. No, that's for you.
Oh.
So I rewrote that section of the annual report on the opioid trust fund.
Okay.
What it said, including available measures of success of programs funded, the amount remaining in the trust fund, a summary of how funds were used in the past year, and any recommendations for future legislation.
I think that would probably cover it. I
I
was
mean,
interested
the
in.
commission's mostly just financial management.
Yeah.
So it's gonna, like, take a while before
Senator Guy.
Okay. We are in the executive session. The motion was by Senator Reagan, seconded by Senator D'Alessandro. Let me just read through the process that we will be dealing with so that we get some consistency. So as we take up each bill, and today we're going to take them up in the order that we had the hearings. If you expect that there's going to be an amendment on that, or if you have everyone's fine with that?
And,
Okay.
and I'll work with Deb.
Okay.
But that would be added to what Senator Whitley proposed.
Correct.
And, okay. Thank you, Mr.
Correct.
Chairman.
Any other discussion on Senator Rosenwald's amendment? With that being none, all those in favor of that amendment, say aye.
Aye.
Aye. Opposed, nay. The ayes have it. Motion carries. It's open for further amendments. Senator Reagan?
No.
What's that? You don't want to? Okay. Draws. Okay, so we are down. The motion before us is ought to pass as amended. Any further discussion? All those in favor of that motion, say aye. Aye. Opposed, nay. Ayes have it. Motion carries. And Senator Rosenwald, wish to take this out?
Yes, thank you.
Okay, next bill is Senate Bill 276.
I'll move ought to pass as amended.
Senator Gaida moves ought to pass as amended, seconded by Senator Reagan. Senator Gaida, you're recognized for your amendment.
Thank you, Mr. Chair. I would propose a couple of amendments. One, the reporting dates to be March 1st and September 1st. That would give us, or a legislature, subsequent time to develop legislation to address any issues that might arise. And the second would be, I'd refer to the Ways and Means Committee, the Committee on Ways and Means as opposed to Finance, since that committee was in fact the genesis of a committee, or, the committee of referral for the bill in its origin.
Okay. Is there a second to that motion? Second by Senator D'Alessandro. Any discussion? There being none, we're voting on the amendment. All those in favor of the amendment say aye.
Aye.
Aye. Opposed, nay. The ayes have it. Motion carries. Any further amendments? Seeing none, we're down to ought to pass as amended. All those in favor of that motion say aye.
Aye.
Aye. Opposed, nay. Ayes have it. Motion carries. And Senator D'Alessandro? And Senate Bill 277. Chair recognizes Senator Hennessy for a motion.
Thank you, Mr. Chair. I move the bill ought to pass and speak to my motion.
Second.
Senator Hennessy moves Senate Bill 277 ought to pass. That's seconded by Senator Gaida. And Senator Hennessy.
Thank you. I just want to speak to the fabulous job that the Office of Professional Licensure has done over the past 2 years now in addressing the healthcare needs of the state of New Hampshire during this pandemic. I think that we all heard the testimony on their proposed amendment, and I believe that we would all agree that at some point it would be extremely beneficial to the state of New Hampshire if we can transition the people who have the emergency or temporary licenses to full licenses in the state of New Hampshire. However, given the testimony that we heard, there are some hiccups right now with how that would be done, the timing of it and the requirements. So my hope is that we can pass this as introduced in the Senate, speed it over to the House, and they can pass it as introduced, and that we can find another vehicle to help address the other information that came up today on trying to figure out how we can transition our helpful workforce that's come into the state into full-time New Hampshire healthcare workforce.
Thank you. Further discussion.
I think that
Okay, you need to put your microphone on, please.
I think that's a good suggestion. I think the amendment's very premature and inappropriate at this time. So work on it, get it done, send it over. I think the thing we all ought to be cognizant of is that 20% of this workforce is on a temporary approval. That's pretty tough when you think of that. And I think of the number of docs and psychiatrists that have temporary licenses. We got to do better in terms of turning things around, because that's not good for the public. I know the labor shortage is critical. I understand that, but if we could, I think, do more in terms of finding out what's going on as far as reciprocity is concerned, that would really help us. I understand that two major agencies, both the Council of State Governments and the NCSL, are working on this, and maybe if we paid a little more attention to getting that together with them, we might be able to expedite this in a much better fashion. But I think it's fine, and thank you for bringing it up.
Thank you.
Thank you.
Any further discussion? Motion before us is ought to pass. Senator Gaida?
Thank you, Mr. Chairman. With respect to another vehicle, Senate Bill 330, which I'm the prime sponsor, having a meeting, including with Dr. Marner and OPLC tomorrow, to discuss just this very thing, because that bill was similar in intent to opening up licensure to out-of-state licensees. So this may be a vehicle for the legislature to take up and go at that issue. Thank you, Mr. Chair.
Thank you. Motion before us is ought to pass. Any further discussion? There being none, all those in favor say aye.
Aye.
Opposed, nay. Ayes have it, and the motion carries. And Senator Gaida, would you like to take this out? Or Senator Hennessy, how about your bill? So Senator Hennessy will take that out. So we have completed our business in executive session. I'll take a motion to come out of executive session.
So moved.
Moved by Senator Gaida, seconded by Senator Reagan. All those in favor say aye.
Aye.
Aye. Opposed, nay. Ayes have it, motion carries. And having concluded our business for a day, we will be adjourned. Good job. Nice, efficient. Try to catch up in